Okay.
Good evening or good morning or good afternoon, depending on wherever in the world you are. It is my utmost pleasure and privilege to welcome you to this webinar by Professor Stefan Talmon on standing in the unclosed litigation. Now, standing in the court or any judicial system is important issue because irrespective of the merit of a claim, unless a party moving to the court can prove that it has legal standing to pursue the claim cannot go anywhere. This is an issue even in some domestic cases when someone else is filing a representative suit or something like a PIL. But perhaps in international law, this is a more pressing issue and we have different models. The subjects of international law, particularly I would say since the Second World War, the advent of the UN system and the formal floating of the idea of human rights has given much more standing to persons as a subject of international law than that used to be the case, perhaps even just before the Second World War. But having said that, although individuals and international institutions clearly since the reparations case have been given standing in some way, their standing before various judicial bodies is not uniform. And in many cases, such as the international investment cases, increasingly individuals or at least companies have substantial access or substantial standing in various international dispute settlement bodies. When it comes to the ICJ, we know that except for states and in case of advisory opinion, there's hardly any standing. But Unclaused, I think, is a very interesting case in many ways, because partially because I guess Unclaused has formulated it in a very distinct way, that states have their standing, then international institutions, enterprises, and also, I would think, individuals. One interesting case study could be perhaps the Grand Prince case, or if my memory serves me well, or perhaps Belize versus France case. So I am not entirely sure how Professor Talmon would cover this topic, unlike some other webinars where I had the benefit of going through a paper. I did not have that paper with me, so I don't know if really my introduction would make much of a sense, or it would really relate to what Professor Talmon is going to deliver today. I look forward to Professor Talmon's talk and of course to your thoughtful questions, dear audience. And I once again would like to thank Professor Talmon for his time from his very busy schedule. Professor Talmon, over to you.
Thank you very much, Professor Islam, for inviting me to share my thoughts on standing in UNCLOS litigation. And good evening to all of you in Dhaka. It's mid-afternoon here in Germany. It's a wonderful sunny day, probably not as hot as it is in your place, but it's very agreeable. So I'm talking to you from my office, and I want to basically present to you today some work in progress. That's why there is no paper which I could have shared, because I'm still looking for answers. So I have lots and lots of questions, and I hope that some of you might have some ideas and may be able to contribute. Perhaps I outline how I got to this topic, standing in UNCLOS litigation. I got interested in the topic of standing in international litigation more generally last year, when I was asked to represent Myanmar in the case brought by the Gambia before the International Court of Justice. And of course, in this case, the question of standing played and plays a very prominent role. But I don't want to talk about the ICJ much, as I have a very long-standing interest in the law of the sea. I have started now a research project on the question of standing in the law of the sea, and especially in UNCLOS litigation. In particular, I'm interested in the question of whether there is room for what is called public interest litigation, or in other words, whether there is an actio popularis in UNCLOS disputes. I assume that much of what I will say today will have to be reassessed in a couple of months' time when the ICJ will issue its judgment on the question of preliminary objections in the Gambia versus Myanmar case, because this will probably be the leading case on standing for a long time to go, and it will have also an impact on standing in UNCLOS litigation. Let me start by quoting my former colleague at Oxford University, Vaughan Lowe, who wrote in 2007 in his excellent introduction to international law, and I quote, "We do not generally reprimand querulous and noisy children in supermarkets, no matter how great a contribution to the public good that would be. Nor do we relieve them of lollipops and crisp packets, no matter how important that might appear to be in their fight against obesity. There is plainly some concept of interest or locus standi at work here, a concept wrapped up in the idea of there being circumstances in which one may properly act and circumstances in which one should mind one's own business." This quote perfectly summarizes the idea of standing. Not everybody has an interest in everything, and not everybody can bring a case before a court of law. Only the person that has a sufficient legal interest may bring a case. We all know the requirement of standing from domestic litigation, as Professor Islam has already mentioned. If someone, for example, breaches the building or zoning laws by constructing an extension too close to their neighbor's house, not just anyone can bring a case claiming a violation of the law. It is only the neighbors that can bring a case because they have a sufficient legal interest being directly adversely affected by the illegal building. Standing, or locus standi in judicio, as it's called in Latin, is also a requirement in international litigation. In case of a breach of international law, not every state can institute legal proceedings before an international court or tribunal, but only those states that, in the words of the International Court of Justice, have a, I quote, legal right or interest in the subject matter of the claim brought. In the Southwest Africa cases in 1966, the International Court of Justice held that international law does not know of an actio popularis, giving each and every state standing to challenge any alleged internationally wrongful act before the court. So, standing in international litigation refers to the right of a state to present a claim to an international court or tribunal. It requires the showing of individual prejudice or individual legal interest in the subject matter of the claim, as distinguished from a mere general interest that can be invoked by any state. There is no question that an injured state, as the state adversely affected by an internationally wrongful act, has standing to present a claim. Non-injured states, however, must establish their standing by demonstrating a legal right or interest in the subject matter of their claim. Now, the subject matter of the claim is determined by the submissions a party puts forward in a case. Before examining the question or the requirement of standing in UNCLOS litigation in more detail, I want to briefly distinguish standing from other requirements of international litigation. First, standing must be distinguished from the question of who has access to a certain court or tribunal. This is dealt with, for example, in Article 291 of UNCLOS, which provides that the unclaused dispute settlement procedures are open only to states parties of UNCLOS and certain non-state entities. This is the standing Professor Islam referred to in his introductory remarks. Although this is sometimes referred to as standing, the question of access to a court or tribunal is a preliminary condition of international litigation that must be settled before we are addressing the question of standing in a more narrow sense. Secondly, standing is not the same as jurisdiction ratione personae, that is, the competence of a court or tribunal to decide the dispute between the state's parties to the dispute. Standing is a condition for the admissibility of the claims brought. Before examining the question of standing, a court or tribunal will have to establish its jurisdiction. Now, Article 288 of UNCLOS provides that a court or tribunal shall have jurisdiction over any dispute concerning the interpretation or application of the convention. And Article 286 of UNCLOS provides that any party to the dispute may submit the dispute to an unclaused court or tribunal. These provisions, however, do not say anything about whether a party to the dispute has a legal right or interest in the subject matter of the claim, meaning whether it has standing. In the Southwest Africa cases, again, the ICJ noted that jurisdictional clauses are adjectival, not substantive in their nature or effect. The capacity to invoke a jurisdictional clause does not settle the question of whether the claimant state has standing. The ICJ held that even the wide language found in the optional clause declarations under Article 36, paragraph 2 of the ICJ statute, encompassing all disputes which the parties to the statute refer to it, does not absolve the claimant state from establishing an individual legal right or interest in the subject matter of the claim. Now, after these preliminary remarks, let me now turn to the question of standing in UNCLOS litigation. The question of standing has so far been discussed only in so-called prompt release cases under Article 292 of UNCLOS, where a coastal state has not complied with its obligation promptly to release arrested vessels and crew upon the posting of a reasonable bond or security. For example, in the Grand Prince case, already mentioned by Professor Islam, the International Tribunal for the Law of the Sea stated, and I quote, "It is necessary here to examine the question of which entity has the locus standi to seek the release of a vessel from detention. In the scheme of Article 292 of the Convention, it is the flag state of the vessel that standi to take up the question of the release in an appropriate court or tribunal." End of quote. In all other cases, including the famous not an issue, because the claimant state was either the injured state or had a clear individual legal right or interest in the subject matter of the claim. For example, in the South China Sea arbitration, the Philippines' submissions all concerned either matters within the Philippines' claimed maritime zones or their territorial scope. In the literature, it has recently been argued that a number of provisions of UNCLOS establish so-called obligations erga omnes partes, that is, obligations owed to all states parties to the convention, or that these provisions in UNCLOS are reflective of so-called obligations erga omnes, that is, obligations owed to the international community as a whole. One such obligation, usually mentioned in this context, is the obligation to protect and preserve the marine environment in Article 192, and in particular, the obligation in Article 194, paragraph 2, clause 2 of UNCLOS, to ensure that activities within a state's jurisdiction or control do not affect the global commons, that is, either the high seas or the area of the seabed beyond national jurisdiction. It has further been argued that in case of a violation of an obligation erga omnes partes or an obligation erga omnes, all states parties to UNCLOS have standing. In support of this argument, reference is usually made to the statement in the 2011 advisory opinion on responsibility and obligations of states with respect to activities in the area, in which the seabed dispute chamber of the International Tribunal for the Law of the Sea held that, and I quote, each state party to UNCLOS may also be entitled to claim compensation for harm to the marine environment of the area in light of the erga omnes character of the obligation relating to preservation of the environment of the high seas and in the area. In support of this view, reference may be made to Article 48 of the ILC Articles on State Responsibility, which provides any state other than an injured state is entitled to invoke the responsibility of another state if the obligation breached is owed to a group of states, including that state, and is established for the protection of a collective interest of the group, or the obligation breached is owed to the international community as a whole. End of quote. The argument that in case of a violation of an obligation erga omnes parties, all states parties to the treaty, and in case of a violation of an obligation erga omnes, all states have standing, is ultimately based on an obiter dictum of the International Court of Justice in the Barcelona traction case of 1970. In that case, the International Court of Justice stated, and again I quote, an essential distinction should be drawn between the obligations of a state towards the international community as a whole and those arising vis-à-vis another state in the field of diplomatic protection. By their very nature, the former are the concern of all states. In view of the importance of the rights involved, all states can be held to have a legal interest in their protection. They are obligations erga omnes. End of quote. Now, my current research now concerns the question of whether a violation of an obligation erga omnes parties or an obligation erga omnes in Unclass actually establishes standing on the part of all states parties to Unclass. From here on, I have more questions than answers, and I would be very interested in hearing your views later on. Here are some of my preliminary observations and thoughts. First, I think that we must distinguish between the question of standing and the question of the invocation of responsibility. The seabed dispute chamber seems to have conflated or mixed up the question of standing and the invocation of responsibility in the quote I've just given to you. And this, to me, seems to be a general phenomenon. In the obligation to prosecute or extradite case between Belgium and Senegal, Belgium claimed that Senegal had violated its obligations owed to Belgium under the Convention Against Torture to conduct a preliminary inquiry and to submit the case of an alleged offender present in its territory to its competent authorities for prosecution. Now, in that case, the ICJ held that Belgium could invoke Senegal's responsibility for alleged breaches of these obligations because these obligations constituted obligations erga omnes partes, in the sense that each state party to the treaty had an interest in compliance with them in any given case. So each state party to the Anti-Torture Convention, including Belgium, could thus invoke the responsibility individually without having to prove that it had been specifically affected by the breach of obligation. Now, this calls for two observations. First, Belgium, of course, in that case was specifically affected because Belgium had asked Senegal to extradite the person. So Belgium had a clear legal interest in that case. So the question of standing as such was not an issue. Secondly, the court, again, as I said before, mixes up here the invocation of responsibility with the question of standing. Now, based on Belgium versus Senegal, the ICJ concluded in its provisional measures order in the case brought by Gambia against Myanmar that, and I quote, any state party to the Genocide Convention, and not only a specifically affected state, may invoke the responsibility of another state with a view to ascertaining the alleged failure to comply with its obligations erga omnes partes and to bring that failure to an end. Now here we had a situation that Gambia, of course, was not specifically affected. It had no legal right or interest unless we construe a violation of an obligation erga omnes, which gives every state a legal interest. And of course, on that basis, the court found in the preliminary objections phase, or not in the preliminary objections phase, in the provisional measures phase, that it had prima facie jurisdiction. And we will see how the court will deal with this question now in its judgment on the preliminary objection. But what we can see is that all these statements refer to the invocation of responsibility. Nowhere is there express mention of standing. That a state may invoke the responsibility of another state for a breach of an obligation erga omnes or erga omnes partes, however, does not automatically establish legal standing or standing in legal proceedings. It is true that the invocation of responsibility includes the phenomenon of proceedings before an international court or tribunal. But the invocation of responsibility and standing in legal proceedings are two distinct concepts. And this was acknowledged by the ICJ in its commentary on the articles on state responsibility. In its commentary on the ILC articles on state responsibility, the ILC notes that the present articles are not concerned with the conditions for the admissibility of cases brought before international courts or tribunals. Rather, they define the conditions for the invocation of that responsibility by another state or states. So, the ILC acknowledges that invocation of responsibility has nothing to do with admissibility. But as I showed before, the question of standing is a question of admissibility. So no conclusion can be drawn from the articles on state responsibility and the invocation of responsibility with regard to standing. My second observation is that there is a distinction to be made between a legal interest in the observance of an obligation erga omnes and a legal interest in the subject matter of a claim. Standing requires a legal right or interest in the subject matter of the claim put before a court. Whereas with regard to obligations erga omnes, the International Court of Justice stated that every state has a legal interest in the observance of the obligation. Now, I think there is a difference between an interest in the observance of an obligation and a legal interest in the subject matter of the claim. The one is a general or abstract interest, while the other one is a specific interest in the outcome of the case. So, at least for the moment, I think that we cannot draw a conclusion from having a general interest in the observance of a certain obligation with regard to the question of whether there is a legal interest in the subject matter of the claim. My third point is that even the ICJ did not equate obligations erga omnes automatically with standing. An obligation's substantive character, say that it is an obligation erga omnes, is distinct from the procedural requirements of jurisdiction and admissibility. The ICJ observed with regard to jurisdiction, I quote, "The erga omnes character of a norm and the rule of consent to jurisdiction are two different things, and that the mere fact that rights and obligations erga omnes may be at issue in a dispute would not give the court jurisdiction to entertain that dispute." I would argue that the same reasoning applies to the relationship between obligations erga omnes parties and the other procedural requirement, namely standing. But I think the best support for the argument that obligations erga omnes do not automatically establish standing can be taken from the Barcelona traction case itself. The case where the court for the first time developed the idea of obligations erga omnes. In that case, the ICJ observed that obligations erga omnes derive inter alia from the principles and rules concerning the basic rights of the human person. However, the characterization of human rights obligations as obligations erga omnes did not settle the question of the admissibility of claims and did not settle the question of standing. The court observed that even instruments that embody human rights do not confer upon contracting states to protect the victims of infringements of these human rights, irrespective of their nationality. The ICJ thus found claims by states other than the state of nationality to be inadmissible because of lack of standing, despite the fact that the ICJ was concerned with obligations erga omnes. In the Barcelona traction case, the court contrasted the situation under universal human rights instruments with the situation under the European Convention on Human Rights, another treaty established to protect the collective interest of all states parties. The court pointed to the fact that the European Convention, in its Article 33, expressly vests a right in all contracting states to refer any alleged breach of the Convention to the European Court of Human Rights. This shows that absent an express authorization of standing, the mere fact that a treaty is established to protect the common interest, establishes obligations erga omnes, does not suffice to establish the standing of all contracting states in any given case. This is also confirmed by Judge Amun, who stated in his separate opinion in Barcelona traction that, I quote, "A state which acts proprio motu for the defense of a collective interest must nevertheless prove the existence of a lawful interest which is legally protected." Equating obligations erga omnes with legal standing would also be difficult to reconcile with the International Court of Justice's jurisprudence on actio popularis, or better, its non-existence in international law. In his dissenting opinion in the nuclear tests cases, Judge de Castro stated, with regard to the characterization of human rights as obligations erga omnes in the Barcelona traction case, I quote, "It seems to me that the obiter reasoning expressed therein should not be regarded as amounting to recognition of the actio popularis in international law." Now, where does that leave us? My preliminary conclusion is that there is no actio popularis in international law, and there is no actio popularis in law of the sea litigation under Unclass. This is in line with general international law, because in international law, the existence of obligations that in the last resort cannot be enforced by any legal process has always been the rule rather than the exception. So we should not be surprised that there are certain obligations that cannot be enforced in a court of law. If the characterization of certain unclaused obligations as obligations erga omnes parties automatically established standing, each of the 168 states parties to the convention could bring a case before a court or tribunal claiming a violation of these obligations, irrespective of having suffered any material prejudice, either directly or through its nationals. This would allow, for example, Liechtenstein, a landlocked state in Europe, to institute a case against Japan for violation of the erga omnes obligation to protect and preserve the marine environment with regard to Japan's plans to discharge some of the nuclear-infested water from the Fukushima nuclear power plant into the Sea of Japan. And we must ask ourselves, was this really the intention behind the law of the sea, that Liechtenstein should be able to bring a case against Japan before one of the Unclaused courts or tribunals? This is even more questionable if we consider that the principle of res judicata would not be applicable in such a situation. Even if Liechtenstein brought a case against Japan, that would not prevent the other 166 parties to UNCLOS to bring a similar case against Japan if they were not convinced by the outcome of the case brought by Liechtenstein. This would lead to a situation where the same legal question could be litigated time and again. Now, my preliminary conclusion is that equating the concept of obligations erga omnes partes with standing would introduce the concept of actio popularis to international law through the back door. In my view, such a far-reaching step cannot be based on a mere deduction from abstract legal principles, but must be based on the consent of states and must find expression in UNCLOS itself. Thank you very much for your attention, and I look forward to your contributions.
Thank you very much, Professor Talmon, for your excellent talk. I have received several questions, although you said you are more interested in answers than questions. The first question that I would like to put to you is that you have referred to the Southwest Africa case, and perhaps rightly so, because that's one of the leading cases on this point. But the question asks you to comment that this Southwest Africa case is perhaps a case which has been most debated one in the history of the ICJ. The court has been accused of backtracking by many scholars. So should that be the best precedent for this? And should a decision of that nature still be relevant today? Thank you for your thoughts on that.
Shall I answer each question right away? Okay. Of course, you're right. This, the Southwest Africa cases probably belong to the group of most controversial cases by the ICJ decided on the vote of the president, who had been criticized for its vote. That the case has been criticized because probably the outcome was not welcomed by especially developing states at the time does not call into question the legal reasoning applied by the judges. And what is often overlooked is that the legal reasoning of the Southwest Africa cases then have re-emerged in separate opinions of judges in later cases. So I don't think that the Southwest Africa cases were a one-off. The Southwest Africa cases were the cases where the court basically expressly pronounced on that question of standing, but it was not called into question in later decisions. So if you think about the nuclear tests cases, for example, where many of the judges refer to the question of standing and also denying that there was a actio popularis in international law. Now, of course, you're right, perhaps international law has changed. And this is why I said the decision of the International Court of Justice in the Gambia versus Myanmar case will be of such importance, because this is the case where the court will be forced to expressly pronounce on that question, because the whole case hinges on the question of whether the Gambia has standing. And the only basis for the Gambia having standing, if we say that the Genocide Convention basically includes obligations erga omnes, which gives all states parties to the convention, or probably all states, standing to bring a case. Now, perhaps we'll have to wait for another 2 months to see whether Southwest Africa still stands or whether we are going into a new era of international law.
Thank you very much for that answer. The next question that I would like to ask is on the policy issues for and against liberal reading vis-a-vis a wider reading of standing. So far you have focused perhaps mostly on law, and I would think that you have made a very strong case. What about the policy issues of this debate? Can you share your thoughts on that, please?
Mm-hmm. Yes, this basically raises the question of what is the object and purpose of international litigation. I assume most people would say that the object and purpose of international litigation, the object and purpose of pacific settlement of disputes, is to remove tensions in international relations. It's basically going to court, not to war, is one of the slogans. So generally, litigation has a pacifying effect. States will be able to fight it out in court, and if they are law-abiding, they will then comply with the decision. And of course, if a state has a legal right or interest in a case, and it brings a case against the wrongdoing state, that purpose will be served. That basically tension between these two states is removed. Now, if we enlarge the group of states that can bring a case, this may bring more tension to international relations and actually removes tension from international relations. The fear I see, or the danger I see, if we allow an actio popularis in international law, at the moment limited to obligations erga omnes, this could lead to more what we call lawfare these days, that the law is used as a means of warfare, that we have perhaps certain states who may not want to enter into a confrontation with another state directly, find a third state, and that third state then brings a case before an international court or tribunal. So a third state that normally could have not had an interest and not have had legal standing in the traditional sense of standing. So I see several drawbacks here if we open up litigation to all states. Apart from that, as I already mentioned, the whole thing may become unmanageable for the international court. Think about obligations erga omnes, which would allow all states to bring a case. As I said, it could not be just one state that brings a case, but if other states are not satisfied with the outcome of a case, they could again bring the same case because there is no principle of res judicata. Think about several states bringing a case. If they would not basically join as a party in the same interest, we might face a situation of a bench in The Hague of 30 or 40 judges, because all these states might be able to appoint a judge ad hoc. So I think we would have to think this through more thoroughly if we want to open up litigation to more and more states, especially more and more states that are not directly affected by the violation of international law.
Thank you so much. Although some would perhaps say that lawfare, however bad it is still perhaps a bit better than warfare. Now, the next question is a long one. It's from one colleague, Mr. Abdullah, Dr. Abdullah Arif. He has asked, let me just read his question because it is a long question. So I would not try to paraphrase. I would rather read it out. He asks, my question is about the suitability of unclosed dispute settlement mechanisms in a climate change scenario. In unclosed dispute settlement, a state's discretion of fisheries regulation in its marine waters cannot be questioned or disputed. However, fish stocks are migrating across borders due to climate-induced changes in the marine environment. As a result, fish stocks that were originally available in a state's marine zones are moving to another state's zone or even to another region. How do we address this scenario? Thank you.
That's an interesting question because there is no direct legal basis, I would say at least, there's no direct legal basis for climate change litigation in UNCLOS. We would have to phrase any such litigation as a litigation concerning the protection and preservation of the marine environment. So that would be the first hurdle. The second hurdle, the question of standing, I don't think would be such an issue here, because if the fish stock migrates due to climate change, and there would actually be a legal basis for climate change action, a case could very well be made that the state that has lost the fish stock is, of course, directly affected. So has a direct legal interest in the litigation. So I wouldn't think that that standing in this case or in this scenario would be the biggest hurdle to overcome. I would probably think that the bigger hurdle here is to devise the dispute as a dispute concerning the application or interpretation of the convention. And we would have to find a way to bring this under the provisions on the marine environment. So we would have to find a way to bring this under Part 12 of UNCLOS. And of course, we have in UNCLOS provisions that deal with the question of pollution from or through the atmosphere. But again, this is pollution of the marine environment through the atmosphere. Now, of course, I know that environmental protection under Article 194, paragraph 5 also includes the fish stocks and biodiversity. But again, I think it probably would be quite difficult to phrase a climate change dispute or phrase climate change litigation in terms of UNCLOS. But as I said, standing, I don't think would be such a big issue.
Thank you very much. The next question that I would like to put to you is, you have referred to Belgium versus Senegal, and rightly so. Now, in that case, as you have mentioned, what Belgium has done is just issued a warrant. Now, assuming hypothetically that you were to argue for Gambia, the Gambian legal team, apart from the note verbal, what else they could do to establish that no, they were not just invoking an erga omnes obligation, they were somehow injured or they were somehow affected, that they have standing? Do you have any thought on that?
Unless we move down that route that violations of obligations erga omnes mean that every state has a legal interest, and that legal interest is sufficient as an interest in terms of standing, meaning that the interest in the observance of an obligation is the same as the interest in the subject matter of the claim. I don't see any credible legal basis. But I said, as I try to outline the hurdles, I think there is a major difference between saying that you have a legal interest in the observance of an obligation. I have a legal interest in a state drawing its baselines in accordance with Unclaused. Yes, that is a general abstract interest I have, that everybody complies with the provisions of Unclaused. And I could say, of course, Liechtenstein has an interest that Bangladesh draws its baselines in accordance with Unclaused. But if there was a dispute between, or if Liechtenstein tried to bring a dispute against Bangladesh, could we really say that Liechtenstein has a legal interest or a right even in the subject matter of the claim? And the claim would be that Liechtenstein wants the court or tribunal to find that Bangladesh illegally drew its baselines along its coastline. So what is the legal right or interest in that question by Liechtenstein? Yeah, I don't see any particular interest by Liechtenstein. Yes, Liechtenstein has, like any other state party to the convention, an interest that the convention is applied correctly and that everybody complies with its obligation under the convention. But what would be the legal interest in Liechtenstein bringing a case against Bangladesh, claiming that Bangladesh wrongly drew its baselines along its coast? I think these are two different questions, and therefore I still think that the Gambia has an uphill struggle here, but we'll see what the International Court of Justice will decide.
Thank you very much. Now, the next question that I would like to put to you is on the Barcelona traction case. So yes, in a way, in essence, it was an issue of protection of investment. Mm-hmm. So should the same standard apply to cases of atrocities, like maybe not just in the case by the Gambia against Myanmar, but in similar situations, who should then be able to take the case judicially? Do you see any thing to do with this type of a scenario where mass atrocity is happening in any part of the world?
I would start disagreeing with your question. Of course, the Barcelona traction case as such was about an investment claim. It was about diplomatic protection, whether Belgium could bring a case on behalf of the Belgian shareholders in the Canadian company. But the court used Barcelona, or the court in Barcelona traction distinguished these kind of bilateral obligations inter partes from the obligations erga omnes, namely the obligations with regard to the protection of human rights, the obligations with regard to the prohibition of aggression. The court even mentions, if I remember correctly, genocide. So the court contrasts these obligations inter partes, like investment protection obligations, with these more important, more general obligations to protect human rights, not to commit genocide, and so on and so forth. But even then, and that's why I was coming back to the Barcelona traction case. Now, even with regard to human rights, which I probably put in the same class as kind of racial discrimination, genocide, because after all, these are all human rights questions at the end of the day. even with regard to obligations concerning human rights, the court still made this distinction, and this is the distinction between the paragraph 34 of the Barcelona Traction Judgment and paragraph 90 of the Barcelona Traction Judgment. And in paragraph 90, the court said, even if you are concerned with human rights, not every state can bring a case claiming a violation of human rights. Only the state of nationality of the person injured has legal standing. Yeah? And so the court itself restricted the concept. On the one hand, it invented the concept or established the concept, but then later on in the judgment, it restricted the concept. And it drew attention to provisions in the European Court, in the European Convention on Human Rights, which has an express provision in Article 33 providing for interstate application. So every state party to the European Convention on Human Rights has an express right to institute proceedings. And the court said, if you don't have such an express right to institute proceedings, then problem, no standing. So, and I think we still have to overcome this hurdle, and the court will have to deal with this in its forthcoming judgment as well, whether it wants to basically get rid of that requirement and say automatically, if you have an obligation erga omnes, you have an interest, and that interest is enough to institute proceedings. Could well be the case. I don't want to rule that out, and that would then open the way for the Gambia to pursue the case against Myanmar further in the court. But we'll have to see and wait. For me personally, I think I still have a problem between rights and interests in the subject matter of a claim and the interest in the observance of a provision of a treaty. I think these are two different concepts.
Thank you very much for that answer and for an excellent session. And of course, thank you so much for your time and kindly agreeing to talk at our webinar series. We are already out of time. Thank you, Professor Talmon, once again. Thank you, audience, for your time. And we would upload it in our YouTube channel. So if you have missed any part of it, you can watch it later on. Thank you.